But for those of you who don't know who I am, my name is Jeffrey Verdon. I practice law in Southern California, or as a lot of you like to say out here, the left coast. And my office is located in the city of Irvine, which is about an hour south of LAX. It's next to Newport Beach, where John Wayne spent his last years. Although I'm in Irvine, this is my 20th year speaking at the MoneyShow, so we have clients all over the U.S., and many of whom are actually overseas. And of course, with the internet and Federal Express and so forth, you can become a pretty global individual no matter where your practice is located. We have great weather out in Southern California, but a lot of crazy people, as they say. The land of fruit and nuts, I've heard it referred to. Our law firm is a boutique tax firm. I want to give you a little background on me so you know why you're here and what I'll be talking to you about. Our law firm is a boutique tax firm, and we concentrate on 3 or 4 key areas. Estate planning for the larger estate owner. For our investor clients, we have strategies that will convert their taxable portfolio income, and that's interest, dividends, royalties, and capital gains, into tax-free income using one of the techniques I'll show you this afternoon. And then we have a national reputation in the area of asset protection planning for those of our clients who want to protect their assets from a financially ruinous lawsuit, which really should be every one of you in this room. It's amazing how few people understand the real exposure they have to liability claims, and we'll talk about that a little bit today. And as I said, I've been speaking at the Money Shows this is my 20th year, and it never ceases to amaze me the efforts and lengths to which many of you will go to get that extra percentage point return on your portfolio, and yet give very little attention to how you can make those portfolios more income tax efficient and more estate tax efficient. I think more importantly, how you can make those portfolios more protected from lawsuits. So we'll talk about that. You see, as a tax lawyer, I believe the successful investor, folks, is measured not by the pre-tax returns, but by your after-tax returns. How much can you spend from your portfolio after you pay the tax man? And sometimes we lose sight of what the real returns are, because your portfolios can have anywhere from a 15 to 40% or more tax layer, which is going to substantially shrink your returns. And if you can get rid of that tax layer, then you're talking about making some significant after-tax returns. But all investors, particularly wealthy investors, have big challenges. The challenges are how to take the estate that's growing, shift it to your children in trusts or otherwise, and not get stuck paying a huge transfer tax and still be able to retain control. The other challenge a lot of you have, if you come from small cities and towns, you may not have advisors in your towns who just specialize in this sort of stuff. And so you're going to get more of a general approach to estate planning and income tax planning, but not the specific approach, not the cutting edge stuff that you'll find if you're working with lawyers in LA or New York or the other big cities. And so we'll talk about that, because as I tell people I meet with, I give lectures on cruises, if your lawyers did this sort of thing, you'd already have it. So you're here today to learn, and I hope to be able to help you depart with some very good information. Now, each of you should have received a green folder. It's our firm brochure, and in the folder there's some materials that I'm going to refer to during my remarks. So have it ready. You should have a pencil and a pen, because there's a lawsuit exposure test I'd like you to take just to sort of quantify exactly or reasonably so how much exposure you have, and if you have a lot of exposure, then maybe you ought to be talking to an asset protection lawyer. But the name of my topic is the 10 tax planning mistakes successful investors make and how to avoid them. The key concepts for the larger estate owner, those of you who are in here who would fall into that category, would be tax-efficient portfolio management. Like I said, converting taxable portfolio income into tax-free income. Estate tax planning, we believe the estate tax is a voluntary tax, and I'll demonstrate it later on, and of course asset protection planning. So you ought to be asking yourself these questions. How can I improve my investment portfolio's after-tax performance? We'll talk about that. If I suddenly die, will my spouse know what to do? And that was really the genesis of the Estate Planning for Women Only workshop, because that workshop addresses the questions and needs of the ladies, and when the men aren't there, they're much more free to ask questions and talk about the issues that are most concerning to them. And if you don't know what kind of an estate plan you have, and your husband passes away, and 93% of the time the husband is going to die, statistically speaking, you're going to be stuck with whatever plan was put together or whatever plan was not put together and there's not much you can do about it at that point. So ladies, you got to get in the game. You got to know what's going on. You got to participate, because we're talking about your future here. And these are discussions that you should be having with your spouse on a regular basis. How do you make the estate tax voluntary? Well, there are people that, wealthy people, can pay lawyers like myself to be able to plan their affairs so when they die they have little or no tax. Joe Kennedy is a perfect example. When he died, he was reputed to have an estate of around $600 million. Anybody have any idea what Joe Kennedy paid in estate tax? No, he paid some. He's a patriot. He paid some, but $137,000, folks. So when Onassis's wife died, Jackie Kennedy, she had an estate of $250 million reputed, paid less than $2 million in estate taxes. So the strategies are out there. You just got to, if you look for them, they're there, and you don't have to pay this big estate tax. The estate tax only represents, folks, about 1.1% of the total tax revenues collected annually. It's not a big revenue producer for the government. It's more of a social tax. But it's very expensive if you're paying in the 50% bracket. And lastly, and you'll hear this theme all throughout my remarks because I think it's so vitally important, are my assets protected from a financially devastating lawsuit? And I dare say most of you would be answering no to that question. So my agenda today is to review some principles of estate planning which I developed in my 28 years as a lawyer, talk about the 10 common mistakes and how we can fix them, talk about how we can work together. I mean, for me, this is a 45-minute job interview. We like to work with individuals who need our services. We're very specialized. If you have a lawyer or don't have a lawyer, but you think some of these strategies might be important to you, call me. Let's talk about it. Get your attorney on the phone. And if your attorney hasn't done this before, I'll be happy to work with your attorney to help put the structure together. We do that with people all over the country. We're not looking to replace your lawyer. We're just looking to enhance the strategic team. And finally, if I have some time, I'll be happy to take your questions. And if I don't, I'll be out in the hallway afterward. All right, let's talk about principles of estate planning. The first one, never sacrifice lifestyle for tax planning. I can't emphasize that enough, folks. I've seen people in my office who have come in and their hands are figuratively tied behind their backs. They've got large insurance premiums they've got to make every year. They're making big gifts to their kids. And they just feel so constricted that they're not happy about the choices they made. You need to be selfish here. This is your money. You spend it. The best estate plan I tell my clients is to spend your kids' inheritance. And if you can't do that, then start looking at some tax planning. But never put the planning for the kids and the grandkids ahead of your own needs. And I see too many people that do that. This is very important also. Get the adult children involved in the process. You've got to get the kids in the game. You need to mentor these, and I'm talking about the adult children. You need to mentor these young people. They're going to be taking over the estate administration. They're going to be making very important decisions later in life. And don't you think you need to see that? You need to be there for them? Too many people don't want to tell their kids how much money they have because they're afraid suddenly they're going to stop working and to lose their work ethic. Or they're embarrassed about how successful they are. And I'm telling you, I've seen the train wrecks in my practice where kids suddenly are thrust, parents die suddenly, the money is thrust upon the kids or the responsibilities of trust management, and they have no clue. And what I've seen, because I speak on a lot of the cruises, is many times the families will bring the whole family together. They form a family partnership. It becomes the investment partnership for the family. They bring the adult children on the cruises, and they learn about investing, and they get a chance to spend quality time together. And this is important stuff. So all the things I've learned in my practice in 28 years, I put this number 2 because I think it's that important. Don't start a tax plan without a roadmap. When I do these cruises, and I'm doing one in October with John Dessauer, I meet with people on these cruises who have a couple of $1 million net worth to hundreds of millions of dollars. And when I ask them, where's the roadmap? Did your lawyer put together a step-by-step description of what all these documents that you've created means? Very few people answer in the affirmative. You need to understand exactly what it is your advisor is wanting you to do before you go ahead and proceed. Because your life is going to change. You just need to know by how much and whether you're prepared to make that sacrifice. That's what tax planning does. You have to get engaged in the process. And things are going to change about how you conduct yourself. And you have to determine whether you're willing to pay the price for the savings. And the price not monetarily, the price in terms of behavior. So make sure you understand what you're doing before you proceed. Folks, don't underestimate the role of life insurance in your estate planning. I know most of us think life insurance is a four-letter word, but every wealthy family that I've ever done planning for always had a bunch of life insurance because they understood that when they give premium to the insurance company, when they die, is going to pay way more in benefits than they paid into the company so they can pay their taxes. And so if you're talking about making prudent investment decisions, if you can pay your estate taxes with 20 or 30 cents on a dollar instead of 100 cents on a dollar, you're far better off. And there's some new things that are happening in the insurance industry, which I talked to the ladies about this morning, which I want to share with you because these are very important developments that you should know about. And finally, folks, fly first class or your kids will. I guarantee you that. And I may change this bullet point, fly privately or your kids will, because we're seeing a lot of that these days, aren't we? All right. Let's get on to the mistakes. No asset protection planning. I see this routinely. Our platform, when we do an estate plan, is we want to make sure there's an estate to retire on or to leave to your kids. And without asset protection planning, living in the most litigious country in the world, you have a very good chance of having those assets taken by a greedy plaintiff's lawyer. Now, how do you know that you have asset protection exposure? Well, in your materials, and this is by no means an exhaustive test, but there's a lawsuit exposure test, which if you complete it and if you answer in the higher end of the answer key, then you ought to be sitting down with your asset protection lawyer or myself or somebody to talk about how we can help button down those assets. Now, what is asset protection planning? Asset protection planning is nothing more than retitling your assets before the fact, before the case is filed, before you know you're going to be sued, such that you can create doubt as to collectability. Litigation is very expensive for both parties, especially for the plaintiff. If the plaintiff's attorney is not going to be able to recover assets, if there's doubt as to collectability of those assets, chances are that lawyer is going to recommend his client settle for a very, very nominal amount of money and very quickly. Our goal with our clients is to get the parties to the bargaining table as quickly as possible, as inexpensively as possible, and make that case go away. And the only way that you can do that is through a properly planned asset protection structure. Now, there are two types of asset protection plans I want to talk to you about, domestic and foreign. Domestic asset protection planning is where you form family limited partnerships, domestic trusts, domestic LLCs, and the assets are put into these structures generally in connection with an estate plan. But this is the problem with domestic asset protection planning. I've been doing this over 20 years and I've seen the problems. The problems are I can protect your assets, I can't protect your cash flow. Let's say you've set up a domestic structure, but then you're sued. You still need money to be able to pay your bills and maintain a lifestyle. The minute you reach into one of these structures and get a distribution, the creditor gets his hands on it. So you can't maintain your lifestyle. Therefore, you have no leverage to negotiate with the creditor. When you set up an offshore structure, a trust that's set up in an overseas country where the laws are much more protective than they are here in this country, you can leave your assets stateside in the trust, at Bank of America, at Wachovia, at Merrill Lynch, wherever you have your bank and brokerage relationship. But if you're threatened with a lawsuit, the trustee moves your assets overseas to a bank that has no U.S. branches, no U.S. offices, and then your money is residing over there in the same investment format that it was here, but now your assets can't be reached. The cash can't be reached. So when you have a bill come up, you send it to the trustee, and the trustee wires the payment to the vendor or the creditor. Now you've got tremendous leverage. Now you've been able to maintain lifestyle, and now your lawyer has a lot more to work with in terms of negotiating with the creditor. So asset protection is important, but between domestic asset protection and foreign asset protection far and away is a much better way to go. I talked about no estate or income tax roadmap, so I won't kick that dead horse. This is important. No living trust or unfunded trust. As I told the ladies this morning, many Easterners don't have living trust. Your lawyers tend to put you in these testamentary trusts, these wills with a trust inside, and I can't for the life of me figure out why. When you have a living trust, you have privacy of your holdings, and you avoid probate. Probate, if you don't know, ladies and gentlemen, is simply the process by which a judge oversees the distribution of your assets. If you saw any of the Nicole Smith trial, you got a sense of what that sort of a process looks like. Now, most of us don't need a judge overseeing the distribution of our assets. And when you're in front of a judge, you're in front of a judge with a lawyer. The lawyer has to get paid. So as a result of that, you've got lawyer's fees, you've got time, delay. A living trust avoids all that. A living trust makes sure that the assets get to your heirs the way that was designed in your estate plan, designed in your living trust. Now, many of you who do have living trusts may not have them funded. This is another little game the legal profession plays. You pay for a living trust, but your lawyer doesn't put the assets into the trust. He doesn't fund the trust. Or he sends the documents to you and expects you to do it. If you're getting your bank statements, brokerage statements, your limited partnerships, if you have them, if they don't read with the name of your living trust on that document, it's not funded. And when you die, the assets go through probate, the lawyer's got to be hired, executor's fees have to be paid, and then it pours into your trust. So make sure if you have a trust, it's funded. If you don't have a living trust, most of you in this room should have one. Also, make sure you have durable powers of attorneys. If you don't have that and you get disabled and you're legally incompetent, your heirs have to take you through an incompetency proceeding, a conservatorship, and they're a very ugly, awful situation. So make sure that you have that as well. Now, folks, if you're not meeting with your advisors at least once every 2 years, we like to see our clients once every year. I tell them that we void the warranty. But I want to see, you should be seeing your estate planner about once every 2 years minimally, because too many things can happen in your life that require his or her attention. And so if you haven't seen your estate planner in 2 years, you should fire that person and go find somebody who will see you on a regular basis, particularly if you're a senior. Now, this is something that really gets me, folks, and I don't know what to say about this. When we had a Republican Congress, we could not get 60 senators to repeal the estate tax. So in 2006, we have a change of Congress, and now we've got a Democratic-controlled Congress. And people are still waiting on the sidelines to see if the estate tax laws are going to get repealed. I'm sorry, folks. If the Republicans couldn't get it done, you're not going to see the Democrats get it done either. So get off the sidelines, get into the game, and get your estate planning done. What's going to happen in 2010, as you all know, is they're not going to have any estate tax. So if you're thinking about doing some serious estate tax planning, you may know what to do in 2010. But if you don't go to that extreme and you're around in 2011, it all goes back to the 2001 rules, which are $1 million exemption for gift and estate, and then the 50% rate kicks in at $3 million, and at $12 million, you're now at 55%, and this is silly. So make sure you do your estate planning if you're getting up in those numbers. So if you're concerned about any of these first 5 situations, go back, talk to your lawyers, give us a call. We'll be happy to help you get pointed in the right direction. All right, now it gets fun. This is the stuff, the sophisticated stuff that you've all come to hear, because I think these are very important tax strategies which all of you should know about. Even if they're not for you, you should know about them because I think they're important. And at some point, they may become relevant for you. Failing to convert your investment income into tax-free income using variable universal life. Now, folks, let me give you just a 60-second primer on the taxation of life insurance. Again, life insurance. I know most of us hate it, but life insurance is probably the best tax shelter we have in the tax code, and I'm going to demonstrate it to you. I'm going to prove it to you. If I went to Pacific Life or Mass Mutual, because they're having the U.S. Open up the street, and I gave them $1 million cash to buy a $1 million premium policy, and they're going to give me some forms to fill out, and they want me to tell them which mutual funds I want to invest in. Well, let's say I check the box Vanguard Index Fund. And that year I made a $100,000 profit. I am not getting a 1099 from Mass Mutual, and I'm certainly not going to get a 1099 to report that gain from Vanguard Index Funds. Why? Because the law clearly states, and it has been this way since the tax code was written, capital gains, interest income, dividend income, and royalty income are not taxable inside of a life insurance policy. But folks, it gets better. If I want to take that $100,000 out of my policy, I simply call up Mass Mutual and I say, I want a $100,000 loan. I'll have a check in 2 days, and that $100,000 profit I made that previous year, I don't pay a penny of tax on it. Why? Because policy loans are not taxable. It's very similar to refinancing your home. But it gets better than that. When I die, the death benefit of that insurance policy, plus whatever is in that contract, whatever investments are in the policy, if I'm entitled to them, pass to my beneficiaries 100% income tax-free, and I haven't even had to pay back that loan. And finally, if you structure the ownership of the policy properly, you're going to have total estate tax exclusion and asset protection by having your policy owned in an irrevocable trust. Now, folks, I don't know any other asset class on this planet that will give you that sort of tax benefit, all legal inside the Internal Revenue Code. But most of your insurance agents will probably never tell you about this because there's no insurance commissions associated with this sort of a product. Now, if you're a big investment person, you've got $5 million or more to put into a variable universal life policy, you can go to any one of the major carriers and they'll give them the $5 million, and they'll give you some selective selection of assets or investments to be in that policy, but there's a very narrow investment parameter they'll let you have. If you're a small investor, you only get their mutual funds. That's why an entire industry of offshore insurance carriers, and I mention the word offshore, but it's really sort of a misnomer because most life insurance companies today, the parent companies are located offshore. Very few of them here are onshore. But these companies recognize the opportunity, if taking the tax code and the taxation of life insurance, if they can issue you a U.S. tax-compliant life insurance policy, just like the one you bought it from Mass Mutual, and they allow you to invest in a variety of investments, like real estate, like individual equities, private equity funds and hedge funds, which are terribly tax inefficient because of all the short-term and phantom income, but make big money. If you can hold those assets inside of one of these insurance wrappers, by golly, you've just eliminated the tax on significant income. Now, these are offshore companies. So you might say, well, does the IRS allow me to own an insurance policy in an offshore company? And the answer is absolutely, as long as you report it. You know, the IRS prints hundreds of tax forms for U.S. people, U.S. taxpayers to complete. They wouldn't print these forms if filling them out and admitting you were doing something offshore were illegal, would they? I mean, it seems axiomatic, but a lot of people believe erroneously that if you're doing business offshore, the IRS is going to put you in jail. And it's just not true. You just have to tell them about it. Now, these companies that I mentioned, they issue U.S. tax-compliant policies, so you're complying with the tax code. The portfolio where you used to have your assets, that portfolio stays right in that custodian. If it's Merrill Lynch or if it's Bear Stearns or wherever, all we're doing is changing title to the assets to the policy. And then with respect to the death benefit, which is a component of a life insurance policy, they're going out to the same reinsurance companies that all the majors go to. And I've listed some of the names up here on the screen. So essentially, there is no financial risk if the insurance company that you bought this policy from were to go bankrupt. The assets in your policy are in a segregated account, and by Bermuda and British Virgin Island insurance law, they are not part of the general assets of the insurance company. But by putting the assets into the policy, or by having the policy invest in those assets, you suddenly cut off the taxation on those investments going forward. Now, here's what the structure looks like. We set up a trust. It has to be a foreign trust because these offshore insurance companies are not allowed to sell policies to U.S. people. So it has to be a foreign trust. Whoops, pardon me. You can get to the loans, or get to the policy benefits through policy loans. The trust will set up a foreign VUL, foreign variable life insurance policy, put the premium or the stocks and bonds in kind, the portfolio into the policy, and then by law, the policy has to set up what's called the SA, a segregated account LLC. It's a segregated account where after the insurance company takes the mortality charges and cost of the insurance policy, the balance goes into this little box, and then under 817H of the tax code, the insurance company has 1 year to diversify your portfolio. And there's certain percentage tests that you have to make. And that's it. This is how a typical insurance policy, where you're structuring it to hold your assets, and now your investment manager can invest in just about any kind of asset that you want. Now, there are certain rules of the road that you have to be willing to adhere to, and let me go over this with you. Number one, and this is the toughest one, no self-direction. If you're a day trader, this is not the structure for you. If you're a control freak, this is not the structure for you. If you're an investor and do not mind a third party, any third party you want, but a third party managing the portfolio in your policy, then you can create some enormous tax benefits. Secondly, you have to diversify. I mentioned that already, which you should do anyway if you're investing. And lastly, it's a technical requirement. The insurance company sets up an insurance dedicated sub-fund. That's what we use the LLC for. And here I put down the legal authority for why this works. And before I came out here, I shepherdized these two revenue rulings, and there's been no additional IRS pronouncements on this insurance structure since, so it's still good law and it's still possible. Okay, let me move on. Failing to properly use estate discounting techniques. For you larger estate owners, you need to know about this stuff. This is where I tell you, I can demonstrate to you that the estate tax is a voluntary tax. And I'll talk about two of these strategies, the superfees trust and the GST strategy. I don't have time to get into the grits and grats, and that's not a food that they serve in the South. It's actually an acronym for a estate planning strategy. Let's talk about the superfees trust, because if you've seen me speak before, I have been talking about this strategy since 1993. Sale to a defective grantor trust, and our firm has saved clients billions of dollars of estate taxes using this superfees trust. It's still good law, it still works, and it's a great way of creating discounts and saving tremendous amounts of estate taxes. It's a strategy to freeze the estate, to shift the future growth to your younger generation beneficiaries through generation skipping trusts. We can create significant discounts, 30 to 50% or more, and it's a conservative strategy. The IRS is aware of it, and there's been some rulings, and we've had to change a little bit of the way that we do this, but by and large, the strategy still works, and it's a very effective strategy. Let me put some context around this so you understand why we use it. Take a client of ours who had an $8 million portfolio. He was averaging about 7% a year. If you run the numbers, that'll grow to about $60 million in 30 years, folks. It's a lot of money. And 30 years is a long way off, but hopefully he gets there and he has $60 million in his portfolio. When he dies, assuming the estate tax rate in 30 years is around 50%, he's going to owe $30 million in estate taxes. So his goal was to shift the future appreciation to the kids, retain the income stream, and do this without any transfer tax. Because as you get into larger estates, the more you try to shift the future appreciation, once you transfer assets beyond your $1 million credit exclusion, you have to write pretty big checks to Uncle Sam, so people don't do that. I'm going to show you how to avoid that. Now, this is an oversimplification. I would need another 30 minutes to take you through the different steps, but simply stated, the client formed a family limited partnership. He put his children in the partnership as 10% general partners. You now have to, you can't manage your own partnership. The IRS doesn't like that. And he put the $8 million of securities and gifted his kids 10%, or roughly $800,000, and he uses a gift tax exemption to avoid any current tax. Then he winds up with a 90% limited partnership interest, folks. Now, ladies and gentlemen, there's only two ways to transfer property out of your estate. Either sell it or you gift it. There's no other way. If he gives a 90% partnership interest, which is worth $7.2 million before discounting, he would owe roughly half of that in gift tax. He's not going to do that. So instead, we created the superfees trust down here. The superfees trust is a special animal. For income tax purposes, it doesn't exist. It doesn't exist. For estate tax purposes, it's treated just like your life insurance trust, where it's out of your estate. See, in the tax code, it's so complicated, you could be an apple for income tax purposes and a grapefruit for estate tax purposes and be completely legal. So what he did was he sold his 90% limited partnership interest, sold, not gifted, sold to this trust. And because the trust is disregarded for tax purposes, it's as though he didn't sell it. But for state purposes, the transfer was complete. So he just transferred $7.2 million out of his estate for an IOU, and he paid down a single dollar of transfer tax because it was a sale and not a gift. And because it was a gift or a sale to a defective trust, there's no capital gains to report. Let me quickly go through the case results because I want to get to some other materials. So he sold his interest for $7.2 million interest, which in 30 years is worth about $58 million at 7%. Without the superfees trust, he has a $27 million estate tax. With the superfees trust in place, he pays less than 3%, assuming 50% bracket. So he saved $25 million plus or minus. Now, I know every one of you in this room would love to save that kind of money with respect to your estate taxes if you just knew how to do it. If you just know how to do it. So here's a strategy which is relatively simple, relatively straightforward, not too many moving parts. IRS lets you do it. You just have to follow the rules. Now, this is a strategy which is very complicated to try to explain, but I'm going to try. I'm going to try. I'm not sure how it's going to come out. This thing is being webcast around the world, and for those of you out there in TV land, I apologize if I don't pull it off, but let's give it a shot. It's a strategy for the larger estate owner. your estate's $10 million and above, you should be looking at this strategy. It's extremely effective for the uninsurable senior. Some of you in this room, maybe you know some people that have a large estate, they just can't buy insurance, their health doesn't allow them to. And so there's nothing they can do about paying estate taxes because their estate's too large to start gifting it away. The senior who would buy insurance, but it's just too darn expensive. I mean, you can buy, if you're a senior, you can buy lots of insurance if you're willing to pay for it, or finances, I'll talk about in a little bit. It's for the family, wealthy family who wants to transfer wealth. And finally, if you've done all the estate tax planning you could possibly do, and you're still going to pay estate taxes, folks, this is the strategy for you. Now, what is it? A little hornbook law on split dollars. Split dollar is a concept that emanated out of the corporate world. In the 60s, corporations, to entice key executives to come to work for them, would offer them in their employee benefit package an insurance policy that the corporation would pay the premium on. The corporation would take a lien against the policy, and when the employee died or retired, the corporation would then wait to get reimbursed for the money that it laid out, and the beneficiaries of the policy would get the balance. And that was the evolution or the beginning of split dollar. Split dollar has evolved to a much different place in the last 40 years or so. Now what we're doing is we're using split dollar to create significant discounts. Father has, we call senior generation, generation one, wants to transfer wealth to the next generation, doesn't want to pay transfer tax. So what we do is the father, or the father and mother, transfer money to an insurance trust for the kids where one or more of the kids is going to be the insured on an insurance policy. I'm referring to them as G2, generation 2. So mom and dad transfer assets to the trust to pay the premiums, and the trustee gives mom and dad back what's called a reimbursement right, the right to receive back the money that they advanced. It's not a gift because the money's coming back. It's not a loan because it's not structured as a loan. It's not a loan because there's no definite date of repayment. The repayment of that money will occur upon the happening of one of several contingent events. And because we don't know when those events are going to occur, when you go to value what the reimbursement right is worth, because every asset in your estate must be valued, the appraisers tell us that we can get a discount of up to as much as 90%. So imagine transferring an asset to the kids, getting back this reimbursement right, and we've just made the asset worth only 10% of its original value. Let's put some numbers around this, and I'll show you what we can do. $20 million estate. We want to get $10 million. You've done the super freeze. So we've frozen the estate. We're still going to have an estate tax. We have more that we can do. We want to do a $10 million funding of this generational split dollar program. So what we do is the client transfers $10 million to the trust. Trust issues a reimbursement right. Now the reimbursement right is only worth $1 million because of this contingency. The fact that the value is determined because if you went to put that reimbursement right out, if you put an ad in the Wall Street Journal, I got a reimbursement right for sale, what will you pay me for it? You'd probably get about $1 million for it. People would assign that much of a discount. That's the fair market value. It will get paid one day, we just don't know when, and because of that contingency, we don't have the ability to value it at par. It must be discounted. So in a 45% world, which we are right now, that $9 million discount creates a $4.5 million savings, folks. But it's not $4.5 million, as I will demonstrate. If you invest $4.5 million at 7% over 20 years, that's worth $30 million. So if you can save your family $4.5 million of estate tax, and it's earning that you didn't pay Uncle Sam, and it's earning 7% in 20 years, that's like leaving the kids an additional $30 million. That's real money. And that's what this structure can do. Now, some of you may not have $10 million in cash laying around to do this. Don't worry about it. A number of lenders, including AI Credit, which is a subsidiary of AIG, Fortune 10 company, will provide the $10 million to you, leaving your money in your portfolio growing at whatever percentage it's growing, and you then loan the $10 million that AIG just loans you to the trustee, and you get back the reimbursement right. You now have a $10 million liability on your estate. You've got a reimbursement right worth $1 million, so if you drop dead the next day, you have a $9 million deduction on your estate tax return for the $10 million loan that you took from AIG. In this particular case, this client died in year 3, and so the interest on the loan was accruing, And so the estate had to pay back $1,237,000 in interest. They got an interest deduction for that. And so the net cost to the family to transfer $9 million of wealth was $358,000 or 3.59%. I dare say, folks, you would pay estate taxes. If you can get your estate tax rate down to 3.58%, you'd have no problem in paying the government whatever, based upon the value of your estate. And this is effectively what financing that deposit to the trust can do for you. Now, I want to apologize for going through this very, very quickly. I need an hour to go through this and have you understand it, but I just want you to, if this is something that makes sense for you, if you're in that category of people who might qualify, write it down on your sheet, give me a call, we'll be happy to talk about it. This is two very important developments in the life insurance arena, and then I think we'll end it. Failing to finance your life insurance premiums. Many of you have life insurance. You continue to pay the premiums, and you're taking the premiums out of your portfolio where you could be earning a much higher rate of return. Today, the whole market has changed with respect to life insurance. There are now lenders out there like AIG who will loan you money, and they wait until you die before they want to be repaid. So you're not having to take money out of your portfolio to finance your life insurance to be able to provide the liquidity that you're going to need to pay your taxes. So you need to know about this. You know, there are a lot of banks that do this, but what AIG does is AIG gives you a loan for life. And as long as you're not in default, and the only way you can be in default basically is go bankrupt, they will wait until you pass away before they want their money back. Now, they're going to accrue interest. You're going to pay interest every year, or you're going to accrue it depending upon your financial situation. But the key benefits are you leave your money in your portfolio earning for you. The financing rates today with AIG, the last one we looked at was about 6.8, 6.9%, all the way up to about 8.25%, depending upon collateral and some other issues. But if you're earning more than that in your portfolio, it's much better to finance your life insurance. Plus, the liability that you incur is a deduction on your 706 estate tax return. So if you die with a loan on the books, Uncle Sam's going to help you finance part of that. Very important development you should know about. Failing to make money selling your life insurance policies. Now, Kevin Yurkis, who's in the back of the room, gave a luncheon today, and I'm sorry if those of you didn't go to it. This is an investment conference, and this is something that is becoming very, very popular. Business Week just did a long piece on it. Of course, they called it death bonds, but it really was a misstatement of what this area really is about. If you have a life insurance policy and you just don't need it any longer, most people will surrender it back to the insurance carrier. You'll get some small amount of cash surrender value after they deduct whatever loans you've taken, and the policy ends. The insurance company no longer has any exposure on the death benefit, and you no longer own the insurance. Instead of doing that, consider the following. Take your policy to Wall Street and sell it to Wall Street. Wall Street is paying big bucks to buy your life insurance policies. You may say, why does Wall Street want my life insurance policy? Well, think about it. If you're between the ages of 68 and 85, and you've got an insurance policy, you have a finite number of years to live. Okay? Wall Street will gladly pay you a fairly sizable percentage of the face amount, take over your premium payments, because they buy thousands of these policies, and then based upon the law of large numbers, actuarially they know within so many years when you're going to pass away as a pool of policies. Their rate of return after taking into account what they paid you and paying the premiums is a double-digit return. It's a very good investment, but there's no risk to Wall Street. A, you're going to die, we all are, and B, the insurance company is going to pay. So the only risk is the time value of money as compared to putting money into mortgage-backed securities and not knowing whether the property is going to have a value, which is what we're experiencing right now. So this is a very important development for Wall Street, and there's a lot of money going into this in this area. As the article pointed out, the Business Week article, about $40 billion in transactions will be done this year, and within 10 to 15 years, they're expecting $160 billion with a B of these senior policy purchases to be done. So you can see we're just beginning to get on the ride this crest. So let me show you what one of my clients. Hey, here's the profit-making idea for you folks. If you're healthy and you can qualify, I've got a client in California, 75 years young. We did a lot of estate planning for him over the years, so we've locked down his estate, we've frozen his estate, but he still has a great deal of insurance capacity that he doesn't need for his planning. So Sal went to Pacific Life and bought a $15 million life insurance policy, which he qualified for at standard rates. But Sal didn't want to use his money. Sal's a real estate guy. He's used to leverage. So he plans to sell that policy in 2 years when he's 77 or 78, health permitting. And he knows that Wall Street will pay him around 20% of face. So Sal buys a $15 million policy. He sells it in 2 or 3 years for 20%. Sal's going to make how much, folks? $3 million. But Sal's a smart guy, so Sal went and he financed the $900,000 it was going to cost him to carry that policy for the 2 or 3 years. And so when Sal sells the policy, he's got a net profit of $2.1 million. And if Sal passes away before he sells the policy, his heirs get $15 million income tax free. Now, folks, I know there are a lot of people around this conference that are giving you great investment ideas. But if you're fortunate enough to be healthy enough between ages 68 and 85, you can get insurance, and there will be a market for that policy to be sold. And if you're like Sal and don't want to put money out of your own pocket, you can get the premiums financed. So if this is something that interests you, you can contact me, contact Kevin in the back of the room. Now, there is a program going around the country called non-recourse insurance where people are actually offering to pay you money up front for you to go buy a life insurance policy. That, folks, is illegal. You must have an insurable interest when you buy an insurance policy on somebody, and if you don't have an insurable interest, I can't go buy a policy on this gentleman, and so I can't offer to pay this gentleman as an investor $1 million to buy a policy on his life and set it up in a way that nobody really knows I'm doing that. And these things are starting to unravel, so you must be very careful about what type of plans you're doing this with and who you're doing it with. Now, the insurance companies don't like this. The insurance companies count on a certain percentage of policies lapsing every year. That's how they build their actuarial models. Well, when Wall Street buys your policy, they're not going to let it lapse. Now, you should never lie on an application when you fill out an application for insurance. And they're going to ask you if you're doing this to buy the policy to sell it or for estate protection. We always advise our clients when they buy life insurance, they're buying it for whatever specific insurance need they have. Now, if they later change their mind and decide, well, I don't want the insurance anymore, I think I'll sell it, you haven't lied on the application. So you must be very honest about why you're doing this, but be very specific about why you're doing this. Yes, sir. You have a question? No. Pardon me. Okay. As I mentioned, now, if Sal gets to 77 and his health changes for the worse, the value of that policy is going to go up. I tell people about a month before you start to sell your policy, put on 30 pounds and start smoking. You'll get a much bigger. I'm just kidding. If Sal gets sick and he may want to retain that policy because his life expectancy is shortened and maybe so. There's no mandate that you sell the policy, but just understand that if you've got the insurance capacity and you've got the health, you can monetize that for very, very large bucks. My last one for the day is: how many of you have a lot of money in your IRA and you sit and you watch those statements come in every month and you won't touch it, and you're at the age where you should be taking the money out? People fall in love with their IRAs. I have seen more people with 7 and 8 digits in their IRAs, millions of dollars in their IRA, and they won't touch it. They want to leave it to their kids. Leaving your IRA on a testamentary basis is a very, very foolish thing. The tax rate for estate and income tax on IRAs could be up near 70-75%. Imagine having $2 million in your IRA, you die, leaving it to your kids, and they wind up getting $500,000 out of the IRA net after tax. It's silly. Start taking the money out of your IRA. Use that to fly first class, as I mentioned earlier. But start using the money out of your IRA. Take more out. In fact, you can use the money out of your IRA to go buy an insurance policy that you might sell in a couple of years or not. So just be aware that if you have a lot of money in your IRA, look at it. Make sure when you meet with your financial advisors that you're dealing with these issues. And don't fall in love with your IRA. Start to use that money. For many of you, you don't need the income anyway, and that's why you're not using it. But all you're doing is exacerbating your income tax problem. I've got a couple of minutes for questions, folks. Can I answer anything for you? The question is, can you set up a limited partnership now and start giving partnership interests away to your children so that you can cap the amount that your estate will grow to? The answer is absolutely. And if you're not doing that, you're really losing out, because every year you don't give that $12,000 away per child, you lose the opportunity to do that forever. But for those of you that have really large estates where $12,000 a year or $1 million one-time gift is not going to make that much of a difference, and so therefore you choose not to do any estate tax planning, consider the sale to that trust, because you can sell 100% of your estate for an IOU, and it's not a gift because it's a sale, and it's not taxable because it's a defective trust. So that's a good point. Is there a question in the back? The income tax consequences of the sale of a life insurance policy that you've held for more than 1 year would be long-term capital gains. There are some ordinary income components, and it would require a little bit more time to go into those issues, so you're welcome to call me. But by and large, if it's a non-modified endowment policy that you purchased and you sell it, it's just like buying a piece of real estate and selling it, long-term capital gains. I've actually had people they object to the fact, well, I have to pay tax on the gain, so therefore I'm not going to do it. I mean, I'm a little confused about that. So you pay a little tax. You're a patriot. The government needs the money, but you've just monetized a great deal of money for yourself. And I'm talking hundreds of thousands of dollars. I don't care how rich you are. Who couldn't use a couple hundred extra $1,000s? I mean, people in my synagogue are doing this and donating half the money to the temple to help the temple with its needs. So it's a great way. If you don't need the money personally, it's a great way to help charities do it for the fallen soldiers and the injured soldiers that come back from the war. I mean, it's really something all of you should look into if you have the health to be able to get it, and many of you probably do. The question? The question was, he's got a 4- and a 6-year-old. He's been advised to wait until they're older before you pursue estate planning. I would definitely not seek advice from that person anymore. Let's say you don't make it to the kids being older, which is why we do estate planning. That's a ridiculous thing for somebody to tell you, but not uncommon. I would look elsewhere for your advice. You should do it because death can occur any time. Yeah, well, it doesn't surprise me. Any other questions, sir? The question simply stated is, how come you didn't talk about putting an IRA money into a VUL? The reason is that they're inconsistent, incompatible strategies. To take money out of your IRA to put it into a VUL, you're going to pay tax on it. And you can't put an IRA into a VUL unless you terminate the IRA or you take a withdrawal. So generally I tell people, take your portfolios, your taxable portfolios, and put it into the VUL because the IRA is not paying tax, and so there'd be no advantages to doing so. Sure. Mm-hmm. Can a person be sued after they have died? Well, the person can't be sued, but the estate, the liability can exist, yes. It depends upon what they're being sued for. The question is, can somebody be sued or their estate be sued after they've died? And the answer is yes, and it would depend upon the item for which you're being sued for and what the statute of limitations are. When I first did my first asset protection plan, it was for a group of OBGYNs. Their liability didn't begin to, their statute of limitations didn't begin to run until the last baby they delivered turned 19, 1 year after the age of majority. So they were going to be 83 or 84 if they retired at 65 before they had no longer any liability. So it can be rather draconian. Yes, ma'am.
Do you have any recommendations for reading or favorite authors and books on estate planning?
Any recommendations for reading estate planning books? I think there's an estate planning for dummies book, which I would get. You can go to my website. I've got a lot of very good basic information on estate planning, and you can always call me. My website is www.jmvlaw.com. Yes. Law, L-A-W.com. Does a will have any value? Sure, it has value. It's better than dying without a will. But because wills make you go through probate by law, and probate is to be avoided like the plague, in most cases, having a will is just not going far enough.